Good afternoon. It's February 16th. This is a meeting of the House Judiciary Committee for 4 bill hearings today, starting with House Bill 403 from Delegate Cardin. Sponsors will have 3 minutes, and witnesses will have 2 minutes. It looks like on this one, it's just Delegate Cardin, so whenever you are ready.
Thank you very much, Mr. Chair and members of the committee. For the record, John Cardin, and testifying favorably on House Bill 403, urging you to give it a favorable report. This came out of, for those of you who may know, was very involved in Grace's Law, which was a bill to help keep our children safe from cyberbullying. We passed the original bill back in 2013, and then we passed a secondary bill after the advent of social media because children were being harassed and tormented online. We had to figure out a way to bring together all the First Amendment civil rights people and all the state's attorneys and law enforcement people to come together and figure out a way to protect our children. I had a call from a constituent who was trying to get a peace order for her daughter against another boy, both minors, and because that boy was harassing and tormenting her on email and social media over and over again, and it was really, as I can tell you the story about Grace, the namesake of Grace's Law, and how it ended in tragedy of her taking her own life. Thank God this didn't happen in this case. What we found out is that when she tried to file the peace order, she was unable to go through because in order for a peace order to be approved, it has to be approved by Department of Juvenile Services, regardless of whether either of the children, the minors, had any involvement with the Department of Juvenile Services. Juvenile Services is required to oversee these and give their approval before there can be a peace order granted. So as you'll see from the testimony, and I have lots of information in it, and I also have the opposition from the Office of Public Defender, which is really interesting because I'm usually, like 99% of the time, we're on the same side on things. And if you read their testimony, it proves my point, which is that, that number one, normal adolescence development oftentimes includes risk-taking and experimentation, but youth tend to mature out of this. But that is not a reason to deny somebody a peace order if a child is being harassed and tormented. So all I'm trying to do is get these peace orders to be able to be granted. And we tried last year. We couldn't do it because the way we tried to do it really messed up the entire system and wouldn't allow any type of peace orders, and this is another way to do it. And if you want me to explain how this bill does that, ask me a question. Thanks.
All right, Delegate Phillips.
I will ask the question. Conway. How does this bill do that?
Okay. Thank you. So right now, if a peace order is applied for by a party, the peace order eventually goes to the Department of Juvenile Services, and they have to basically review it and make a decision to approve that it should go through to the. It doesn't go to the State Attorney's Office. It goes, I guess, to the commissioner or to the master or to the judicial officer that would then grant the peace order or review it and then grant it. And what's happening is Juvenile Services these issues tend to be very, very, very low on their priority list. They're dealing with issues with all the people that are involved, all the children that are involved in Department of Juvenile Services. The cyber harassment of one child because of an email or a threat on social media or some comments that are being made is, I won't say ignored, but is generally just not really taken seriously. Let's be honest, it's not taken seriously. So none of it gets through. So what this does is this requires the issue to be forwarded directly to the state's attorney, so the state's attorney's office can review it, and they can make the recommendation to the judicial officer for it to happen.
If I could have one follow-up. So what you're saying, there still is a review process that will take place. We're just trying to, almost in essence, get the juvenile services component out of the decision making. They just automatically send it over, and then the state's attorney's office, or it could be maybe a commissioner, it could go back.
They could then forward it to the commissioner, to the master, or the judge who's going to rule on this. If one of the two people involved is already involved with the Department of Juvenile Services, I'm not interested in that. Then they should be able to weigh in and say, it's appropriate, it's not appropriate. But these are two kids who've never had any interaction with juvenile services because they don't have any record. Nothing. There's nothing. One's in school. They're both in school together. They've never been in trouble. One is all of a sudden learned how to use the internet, is doing things that he shouldn't or she shouldn't be doing to the other person. They just want to get a peace order that says, stop doing this. And we're trying to get them to stop doing that. And all peace orders are reviewed by a judicial officer. They make a determination whether there was a threat and whether it's appropriate or not.
Delegate Conaway, and then Eric Han, and then Valentine.
Oh my God.
In your description of the bill, you described the person's making a complaint as being a party, and then you went on to say two kids. So are we saying that these two kids are going to bring this complaint against, or one of the kids, the juveniles, are going to bring the complaint against the other juvenile without adult interaction? Is that what we're saying?
So, I actually might not know the answer to this question.
What I'm saying,
Wow.
what I'm saying
But
is,
the question is, can a juvenile bring the peace order without the approval of the parent?
yes.
In my practice, I've always had the parent who has done it on behalf of their child. So I don't know whether a child can do it themselves, but I wouldn't see any reason why a child shouldn't be able to. It's, again, got to be reviewed by a judicial officer to determine
So you're saying, I'm not trying to be aggressive. You're saying that you don't see any reason why your child could be able to bring a complaint against another child without you having knowledge of it?
No, I mean, if I, as a parent, I would want knowledge. The question is whether the child can sign the paperwork. And now I'm thinking about it, I don't see how it can be brought because it has to be signed by somebody over the age of 18. So I'm answering
So
I'm
we're
answering the
going
question.
to amend this, or how do you think we're going
No, I mean, I don't think it has to be amended. I just think that it's the parent of the child that would bring the peace order.
And that's in this bill?
Yeah, I don't think that this bill doesn't change who signs the request for the peace order, the application for the peace order. This bill doesn't change that. It just says that application has to be forwarded to the state attorney's office.
So just to be clear, now you're saying that a parent would have to be aware of the fact, and they would have to sign for the juvenile?
I think that an adult would have to, and it would have to be
Okay, because you didn't say that earlier, right? Am I correct?
No. Well, if I didn't, I apologize for neglecting to say that.
Thank you very much.
Delegate Eric Han, and then Grammer.
Thank you, Mr. Chair. Yeah, I think it would be, you'd have to be either a parent or guardian or emancipated minor is my guess what the rule would probably be. So in terms of timeline, how do you foresee this shortening? So it's been taking too long or just not being addressed essentially. What are we looking at timeline? Because some of these kids I know are afraid to even go back to school the next day.
Right.
Have you any anticipation of how this would improve?
No, I anticipate that it will quicken up the results. I can't tell you that it'll happen in a day. The idea is that we want to be able to. One of the things the Office of the Public Defender, who may be testifying after me, they say that this will increase prosecution. The goal for stopping cyberbullying is not to increase prosecution or to try and prosecute these cases. It's to get the message out that you need to stop, and if you don't stop, you're going to get in trouble for doing it. This is about peace orders. This is not about prosecution.
Right.
This is about getting a peace order in place so that if you violate that peace order, then yes, there can be ramifications for that. And that's
Yeah.
all that this is about.
It sounds really reasonable to me.
So if we're biting off more than I'm trying to chew here, I'm happy to narrow it down. But I think that's all this does, is it says that these peace orders have to be forwarded directly, these peace order applications have to be forwarded directly to the state's attorney.
Yeah, sounds narrow to me.
Thank you, Mr. Chair. Why does any peace order that involves two juveniles that are not involved in the Department of Juvenile Services, why does any crime filter through DJS if neither child is in the system?
Right. And so that was the question that I asked for now the last 2 years. And the answer that I am given, and we can have next time Department of Juvenile Services comes, they can also re-explain it, is that when it comes to juveniles and juvenile offenders or alleged offenders, the jurisdiction should be under the Department of Juvenile Services because we don't want to handle these as if they are crimes that we handle with adults in the adult system. So they don't want this to look like it is being handled as an adult, as some sort of an adult-based crime. And that's the reason why it goes through juvenile services. The problem is that because of that, it's sort of like this area that happens to get lost in the whole system and nothing happens. And all we're trying to do is stop the behavior because we want to stop it before it gets to the point where we're talking about the last few days where children can really get harmed psychologically or physically.
Okay, thank you.
Delegate Simmons.
Thank you, Mr. Chair. Is the bullying, is that a criminal offense?
It is now.
Right. So
Yeah, I mean, there's a definition. There's specific definitions to it. But yes, there is a criminal statute.
so will this work hand in hand with your proposed legislation?
Well, the idea behind this is that if in fact it gets to a point where a prosecutor feels as if they need to prosecute, they could. We're really talking about way before that, where we don't want it to get to that level.
Right.
So the answer is yes, this could work in conjunction with that, but hopefully to deter the need for further prosecution.
Yeah, and I get it now. And I know we listened to a lot of testimony from attorneys about the fact that, they don't write the laws, they enforce them. So if we write laws for them to enforce, and one of them being is that is a arrestable offense, then one would expect that they would take action on that regardless of it, no?
Right. And to your point, yes. So, and what I think the OPD is going to say, and I don't want to put words in their mouth, is that we are creating an opportunity for there to be more arrests and more prosecution when we shouldn't, especially when it comes to minors. And the idea behind this bill is to actually reduce the number of prosecutions that we have the law on the books to be able to do it. But if we can get these peace orders out there and get people to stop misbehaving, we don't have to actually get to that level where the police and the state attorneys are required to then start to prosecute.
Yeah, so, my concern would be once law enforcement is involved in something like that, they're going to act on the law, not on, interpretation of the law. They're going to execute the law based on how it's written. So that would increase the amount of juveniles being detained or escalation of charges based on that law.
I think I answered it before, but I think that this legislation will presumably keep kids in the straight and narrow if it's done properly, so that there will be less opportunity for children to harass other children and therefore be subject to racist law and prosecution thereof.
Thank you, sir.
All right, thank you very much. Do we have Jeremy Zacher here? If one person signs up in opposition, you have 2 minutes when you are ready.
Thank you. Good afternoon. My name is Jeremy Zacher, and I've been an assistant public defender in Baltimore City's Juvenile Division for 9 years. And the Maryland Office of the Public Defender asked this committee to issue an unfavorable report on House Bill 403. I did have some prepared remarks, but based on what Delegate Cardin said, I'm just going to, speak from what he said. My reading of this bill is that it is not limited to peace orders. This bill and this change in the statute would open up more complaints to being forwarded automatically to the state's attorneys. Right now, when a complaint or a peace order comes in, DJS receives it first. They do have an evidence-based tool to assess whether or not the complaint needs to be forwarded to the state's attorney's office, and I discussed this tool in my written testimony. But the way the statute is written, or the way that the change to the statute is written, it would not only forward peace orders directly to the state's attorney, but complaints as well. And not every case comes in as a peace order. Many times these allegations of harassment will come in as a formal complaint. The Public Defender's Office is laser focused on implementing evidence-based solutions to these problems. Some cases, the evidence-based solution will be a diversion, and on some it will be forwarding to the state's attorney's office. Our concern is that automatically forwarding these cases to the state's attorney's office will result in more prosecutions of youth, more unnecessary prosecutions of youth. And so we're asking for an unfavorable report. Thank you.
All right, are there any questions? Yes, Delegate Grammar.
Written differently to clarify the intention of the bill, would the OPD object to it?
So I'm only going to take a position on the way the bill is written today. We would want to review exactly what changes were made and discuss it amongst ourselves before we came back with a answer to your question.
All right, thanks.
Yes, Delegate Shred.
Thank you, Chair. Do you have some recommendations on how we can revise?
Well, I heard Delegate Cardin talk about a very specific example. I would first suggest looking at that district or that office to see what the holdup was and why DJS came to the resolution that they did. Because there may be a reason for which I'm completely unaware. I heard Delegate Cardin say that these things are moving too slowly. That may be something that could be addressed just by talking to the new secretary of the department, for example. I'm not sure a statutory change would be useful at all. Because if we change the statute and your complaint is, well, things are moving too slow, well, what's to keep things from moving too slow with the change? So I would first recommend discussing it with the department to see if there's anything they can do to facilitate the process.
Okay, thank you.
Delegate Conaway.
Thank you, Mr. Chair. Thank you for coming in to testify today. My question is in reference to page 2, number 3, citations issued by a police officer. So there may be citations that are issued by a police officer in reference to, let's see, what may have happened. And you're saying that'll be forwarded to the state's attorney's office. And what kind of action could they potentially take?
State's attorneys have a choice to make. They could do nothing. They could return it back to DJS intake and ask DJS to talk with the family and provide services, or I believe they can prosecute as the law allows.
Okay, thank you very much.
Thank you very much. That concludes the hearing on House Bill 403. We will now go to House Bill 405 from Delegate Foley. Do you have a panel you'd like to bring up with you?
Yes, please, Mr. Chairman. If I could bring up my panel, and I also have 2 panelists who are online.
Yeah, we've got everybody straight favorable except Thomas Koenig was favorable with amendments, so we'll do Thomas Koenig last. But otherwise, you can begin when you are ready.
Okay, thank you, Mr. Chairman. For the record, I'm Delegate Linda Foley, and I'm presenting HB 405, Criminal Law, Animal Abuse or Neglect Penalties. I want to thank the Judiciary Committee for giving me the opportunity to present this bill. It would significantly strengthen protections for animals that are severely neglected and willfully abused. HB 405 would strengthen current penalties if the conditions and treatment of an animal are so detrimental to its well-being that the abuse or neglect directly causes the animal's death or veterinarian-directed euthanasia. Currently, the maximum penalty for any animal abuse is 90 days in prison and/or a $1,000 fine. The penalty for severe animal abuse is no different than the penalty for minor abuse infractions. This bill would increase the penalty for convictions for severe abuse causing death to 3 years in prison and/or a $5,000 fine. The bill would also prohibit convicted abusers from owning, possessing, or residing with an animal for a court-ordered period of time. Situations of extreme neglect in the care of animals, such as those found in deplorable, unhealthy, and unsafe living conditions, have been well documented by various states' attorneys' offices in Maryland. However, the current animal abuse statute has rendered it difficult to adequately prosecute these severe abuse cases. Severe animal neglect or abuse doesn't happen frequently, but when it does, our justice system needs to be able to address it properly. At least 6 other states, including Virginia and Washington, D.C., provide enhanced penalties for severe neglect or abuse of animals. I'm also offering a sponsor amendment that would require a second veterinarian's opinion concerning the required euthanasia of an animal due to severe abuse or neglect. The opinion could be rendered either before or after the animal has been euthanized. And I'm also considering an amendment suggested by the Maryland Association of Soil Conservation Districts that, in the case of recommended euthanasia of agricultural animals, the second veterinary opinion would come from the state veterinarian. As we all know, animals have no voice. Domesticated animals in particular are entirely dependent on human beings for their care, feeding, and medical treatment. When that dependency turns into abuse, it must be appropriately addressed. These animals contribute to our society in a myriad of ways, from assisting us as support animals to just being a comfort to us as pets. And we should penalize those people who take advantage of their trust and helplessness by abusing or neglecting them. I hope this legislation will not only appropriately hold severe animal abusers accountable, but also will serve as a deterrent, fostering more responsible ownership and care in our state. I respectfully urge that the committee adopt a favorable report on HB 405. Thank you very much.
All right, whoever would like to go next.
Don't push the button.
Don't touch that.
Don't touch the button.
Got it.
I want to thank Mr. Chairman and the committee for a chance to speak favorably on House Bill 405. My name is Greg Lawrence. I'm the Chief Veterinarian for the Montgomery County Office of Animal Services. In my 20-year career as a veterinarian, I've seen all degrees of animal cruelty. And what I've noticed is, particularly under 10604, some of these crimes result in severe pain and suffering of these animals, including death and required euthanasia. And, you know, a good example of one that we resolved recently, where the perpetrator, just by simply not taking her dogs to the vet and allowing the flea infestation to fester, that one dog died before we were able to intervene. Another dog was euthanized a few days after we intervened, and several others would have died had we not intervened in the coming weeks. After another approximately 2 years, she'll be able to purchase and own animals again in Montgomery County, and just repeat the cycle that she has started with those other dogs. And we've seen this with starvation cases, other failure to provide cases with sanitary conditions, and this bill would help prevent animal suffering long-term with some of these more severe outcomes that we see in these cases. I would encourage the committee to have a favorable report on this bill. Thank you.
Whoever would like to go next.
So I'm Jack Breckenridge. I'm the cruelty investigator for the Montgomery County Office of Animal Services. The one of the highlights that I want to draw your attention to, the ban on owning animals is a part of the sentence instead of a condition of probation. I have a couple cases in my career where people have been watching somebody else's dog. Like I had a dog trainer who worked a dog to heat stroke, and probably because of financial motivation ignored that, and the dog died in his care. Upon conviction, right now, he can be prohibited from owning, possessing, residing animals for 3 years. And this bill would allow us to change it to be, as a condition of the sentencing, that the judge could order a longer period of time, or even potentially stop him from working with animals again because of his poor management of that case. And another case I had where a dog bather had, basically she was trying to do more volume than she was capable of, so she engineered a situation where the dog choked itself to death when she was out of the room. And currently, if somebody's convicted of specifically that crime, that's misdemeanor neglect, and we can ban them from owning, possessing, or residing animals for 3 years. Owning, possessing, or residing with animals for 3 years. And I think if we all, any pet owner in this room, we can all say, if somebody kills my dog, there needs to be a more substantial penalty to that. Thank you, and I'd encourage a favorable report on the bill.
Okay, would that make you Thomas Koenig in the center, sir? No?
I think there are two people that are
Online. Yeah, why don't we take the online folks then? We'll start with Carlotta Woodward and then Michael Moore in that order. When you are ready, you have 2 minutes.
Thank you, Mr. Chair and members of the committee. My name is Carlotta Woodward. I'm an assistant state's attorney here in Montgomery County. I'm the chief of the juvenile division, but I also handle all of the animal cruelty prosecutions in my office. And I'm testifying on behalf of John McCarthy, as well as the Maryland State's Attorneys Association, for a favorable report. I would like you all to imagine if you had 66 dogs confined to less than 1,200 square feet in cages stacked on top of each other. Cages that aren't the appropriate size for those dogs. Some dogs are loose. Imagine that those dogs are living in their own feces and urine, which has caused significant skin infections, and their fur is matted. Some of those dogs had masses that were left untreated. The living conditions were unsanitary, and some of the dogs' eyes and ears became infected. One of those dogs had to have an eye removed. Another dog was blind from untreated glaucoma. And ultimately, as a result of the conditions and the failure to provide vet care, 3 of the dogs had to be euthanized. Imagine a dog, and Dr. Lawrence talked about this, needing a blood transfusion because of flea anemia. And when the vet attempted to take the blood from the dog, there was not enough blood in that dog's body to get a blood type in order to determine what blood was necessary for that transfusion. That dog had to be euthanized because of the flea anemia, and simply treating that dog for fleas would have saved that dog's life. There needs to be an enhanced penalty for the animals who die or need to be euthanized as a result of the acts that are currently enumerated in 10604. I speak for the victims who are voiceless, and I ask for a favorable report on House Bill 405 on behalf of the State's Attorney's Office in Montgomery County and the Maryland State's Attorneys Association. Thank you.
You can go ahead when you're ready, Michael Moore.
Thank you, Mr. Chair. I'm Mike Moore. I'm with the Frederick County State's Attorney's Office. I'm on the executive committee here. I'm speaking on behalf of the Maryland State's Attorneys Association as well, asking for a favorable report on this bill. 2 things that stick out to me. One, this bill is logical. There should be an enhanced penalty for an animal that dies as a result of abuse or neglect. The second thing that I want to highlight for this committee is the direct correlation between domestic violence and aggravated animal cruelty. Sorry about that. I would say that here in Frederick County, we've seen cases with the direct correlation between domestic violence and animal cruelty, cases involving convictions for domestic violence and aggravated animal cruelty, where the defendant and his abused his girlfriend and also killed baby bunnies. There's another cases where the defendant killed one of the girlfriend's kittens by putting it in the toilet, flushing it. The head was completely twisted. The cat suffered a broken leg and a tooth missing from the abuse. There's countless numbers of cases, including another case where a cat was severely beaten. The girlfriend was severely beaten. There's no difference between the penalty of severely beaten and animals that die right now provided in the statute, and I would ask this committee to consider a favorable report. Thank you.
All right, good afternoon. I would like to thank Delegate Foley for her sponsorship of HB 405, and with the with amendment portion is my support for the amendments already presented by Delegate Foley. So, and I also like to thank the committee for giving me the opportunity to present my support of this bill. For the last 18 years, I've served as the director of an animal services and animal control agencies. During that time, I've overseen a work of officers required to enforce animal-related laws and regulations. I've witnessed my fair share, probably well beyond my fair share, of cases involving severe neglect in the care of animals. A number of these cases included homes that were so appalling, officers were required to wear personal protective gear, including enhanced masks, just to go in and secure the animals. Animal welfare professionals across the state commit their professional careers to better the lives of animals and to relieve suffering, pain, specifically of those subject to deplorable levels of care, and unfortunately, in many cases, fortunately, they have the opportunity to do that, and they do a great job of it. They then must trust the legal system to convict those responsible, particularly those who are charged under 10604. However, in some cases, the opportunity to relieve suffering and pain, better the lives of these animals, are taken away from us, because these animals are subject to such conditions that directly cause the death, that outcome cannot be fixed or made better. HB 405 would go a long way in holding those responsible for the unnecessary death of an animal or causing the animal to be euthanized where there is no other remedy available. When the unnecessary failure to provide the basic care provisions found under 10604 causes the death of an animal or made it necessary to humanely euthanize that animal, the penalty should also enable the courts to ban ownership for a period of time that goes well beyond the standard probation periods. We have identified 24 states that ban ownership of animals based on misdemeanor conviction of animal neglect. I respectfully urge the committee to adopt a favorable report.
All right, Delegate Eric Han and then Embry.
Thank you, Mr. Chair. So I heard the sponsor mention livestock. Are you intending for this bill to apply to farm animals as well?
Thank you, Delegate, for the question. Yes. And in the case of agricultural animals, the amendment that I intend to put forth would require a second opinion from a veterinarian about euthanizing animals, and that opinion should come from the state veterinarian.
Okay, I'm to my knowledge, agricultural animals are in a different category from other animals, but I'd certainly like to know more about the process for euthanizing livestock. To my knowledge, there's no requirements currently on farmers to get animals euthanized by a vet.
I'm going to defer to my panelists to answer that.
Yeah, 10604 is meant to cover all domestic animals, which includes agricultural animals. And as such, we're talking about the euthanasia of that animal when there's no other remedy for it. So the veterinarian, and many times in consultation with representatives from the Department of Agriculture and our local Office of Agricultural Services, we make decisions about this when we know that to relieve suffering and pain, and again, agriculture includes poultry and waterfowl and animals like that they're suffering so bad that the euthanasia has to occur. Most of the time, and Dr. Lawrence can talk to it more because he's been involved in it more personally, but most of the time it is the state that decides how that euthanasia is going to occur. They have the methods and mechanisms to make that happen.
Okay, so just in practice, people that own livestock, poultry, things like that. We're not coming to anybody to ask if we should butcher an animal. Just not what's happening. So I'm not sure what the law says, but farmers like me, if I see a sick bird or one that's been abused by the other birds to the point where it's now refusing food, I'll butcher that animal immediately, and I'm not calling anybody for permission. So if that is the law, it's a problem, and we should immediately get rid of it. My other concern was the mention of the flea infestation. There was a year, maybe 2 years ago, where we could not get the fleas under control. We would alternate, I'm sure you guys know as vets, alternate different options. The fleas were so unresponsive that year, and I still don't know why. Now my animals, they did okay, but still, it was a problem. And so I'm concerned with over-criminalizing people who, there's a legitimate scientific problem that we face with these aggressive fleas that could not be killed by either major formula.
Sure, and that's a great point. Thank you. And resistance to the treatments and things is something that we're dealing with as an industry. But if this 10604 is not going to apply if you're not failing to provide care. So if you're failing to provide care and that care is not effective,
right,
then this doesn't apply.
Okay, how would people know? So let's say a neighbor reports somebody, their animal's infested with fleas. How would you guys find out if the elderly person had been treating the animal? And what if she's not responsive, doesn't participate? You guys just remove her animal. How is she going to make sure that you know that she's tried? She's to provide some kind of proof, essentially, that she's done flea treatments?
So we verify vet care on cases like that all the time.
Well, this would be, she orders it off Amazon. I mean, I don't go to the vet for flea treatment.
Sure, yeah. Well, and if you show me that you did that, or if we know that there's something going on like that, and a lot of times what our officers end up doing on complaints like that, it doesn't get to the level of criminal charges.
Mm-hmm.
It gets to the point of education. Hey, are you doing the right thing? Is there something better you can do?
Right.
Can we plug you in with a vet that might have the answers? Or a lot of times our officers will call our staff vets and just kind of get the guidance.
Yeah, that would be my last question. I mean, there's been just in the last year a 10% spike in veterinary costs. So the problem we're facing in many cases is people literally cannot afford to do some of these treatments that you and I might deem as necessary. I might be able to afford it. Lots of people I live near literally cannot afford to take their animals to the vet all the time like they may have been able to do 5 years ago.
And in Montgomery County, I can speak specifically to us, is we've been developing relationship with veterinarians to get people in at lower cost. The program that comes to mind that we used recently was an Angel program at a vet, the big vet referral hospital in Gaithersburg, where they'll actually provide no-cost care for homeless people and stuff of that nature.
Okay.
But we're not criminalizing pet owners that can't sustain. We're criminalizing, like, the dog groomer whose house is infested with fleas and the feces is several inches thick on the carpet and things of that nature.
I mean, that's obviously the kind of cases we would like to see, although I guess with this law, the way it's written, the discretion would be up to the state's attorney's office, essentially.
Correct, yeah.
So I think that's my concern, that they would have to analyze each person's financial background. I just don't know how much care will be given in every jurisdiction to considering people who are just struggling financially because of the economic issues we're facing.
Yeah, I understand.
So thank you guys very much.
All right, delegates Embry, Tolles, Simmons.
Thank you so much. I have two questions. The first is, how do you enforce the ban that extends past the period of probation? What is the legal mechanism for enforcing that?
Go ahead. Well, so
speak into the mic.
So that's a fun question. So it can be complex. Generally, I have not found anybody with a prohibition for even unsupervised probation where they've violated. And I think that it would become an issue if we caught them violating again. But we also don't want to go profiling everybody and watching everybody for the rest of our lives.
But I understand violating probation, but if they're not on probation.
If they're not on probation.
What would it be? An administrative action or?
Carlotta?
Yes, thank you.
I'll let the
I was trying to wave my hand. I didn't know exactly how to do that.
Thank you.
I think most of the time is that they're currently, I believe, in Mr. Koenig can talk about this, is that I think there's currently for aggravated that it can be a lifetime ban. I think what would happen is that the court would issue an order. And then obviously if we determined that there was a violation of that, it would be a contempt of that order, a contempt proceeding that would come back. Haven't seen it or haven't done it in my time, but that would be we were going to do it in another case, and that was what I was going to ask the court to do, was issue an order, and then we would do contempt proceedings, so due process would be available to the individual violating.
Thank you. That makes sense. And my second question, I don't know if you've seen, and I'll direct this to you if you don't mind, Ms. Woodward. The fiscal note had some conviction rates, and I don't know if they're accurate, but for circuit court cases, it said in 2022 it was less than 5% of cases where this was charged. I don't know if that just means someone pled guilty to a different charge, but I just was curious if there's an issue with being able to secure convictions in these types of cases.
I will tell you kind of how I do things, but 10604 typically is going to be in district court. And I can't bring it to circuit court because of the specific time frame, because it's a 90-day offense. So most of the time when I have these cases and trials, I am dealing with them directly in district court. I don't find there is a difficulty of securing convictions, specifically in my cases, but I do take into account a lot of different things. When I meet with the animal services, we're talking about, is this a mental health issue? Does this person need to go to mental health court? Does this person need to have a stet in order to do certain things? What is the level of necessity in each one of these particular cases? And I think one of what was mentioned is about those that can't afford things. How is that taken into, we take that into account, and I know that that can't be stated for across the state of Maryland. That's how I do things here. So, but when I'm going forward on a trial, which specifically the flea anemia case was my trial, and I did have a full day trial in district court and won on all counts on that particular case. So I think there's a level. I don't see any issues with convictions. I think that it may be of how we're trying to resolve these cases based upon the totality of the circumstances. And I don't know if I answered your question.
Yeah, I want to just add real quickly is there's a lot of allegations that are resolved before they even get to the point of charging. Especially when we have cooperating individuals who are just need a little bit of time, a little bit of repair, a little, get their life together, so to speak, so that they can care for these animals. And we will hold those animals and then look at the case. But generally, if they've do all the right things that are covered by 10604 and they meet those requirements, then we go and give the animals back to them. So they don't necessarily go to conviction.
That all makes sense. And I don't want to put anyone on the spot, and I won't belabor it, but if you want to later look at the numbers in the fiscal note, it seems to be charged cases, but I may be wrong. But I thank you all so much. I have no further questions.
Delegate Tolles.
Thank you, Mr. Vice Chair. So Delegate Embry asked my first question in terms of enforcement. So my second question is 2A rather. So according to the current law, you can be in prison for 90 days and or a maximum of $1,000, and you're changing it to 3 years or $5,000. Is that correct? Delegate Foley?
Yes, Delegate, that's correct.
Okay, thank you. And so my question is for the ASA who deals with these cases in Montgomery County. To your knowledge, have anyone ever been jailed for a period of time for animal cruelty or neglect?
For animal cruelty under 10604 and 10606? Or either one?
Either one. And what were the circumstances?
Yes.
And what were the circumstances?
I had a specific case in which I had an individual who killed his girlfriend's dog. There was another case where another individual who was dating somebody killed their dog, and they went to jail. With the significant component typically in 10606, which is the aggravated animal cruelty, which is the intentional act. You're usually dealing with somebody who kills a dog or who kills an animal, who cruelly beats them or torture. And in those particular circumstances, we run their guidelines and determine what is appropriate. I recently had an individual who did kill a puppy and was given house arrest for a period of time in lieu of going to jail because of the financial circumstances of that particular individual. So I do see that occurring. And the 66 dog case that I spoke about under 10604, that particular judge gave that individual 6 months in jail for the actions. Ultimately, she only served a few days because she appealed the case, but if you're asking, has that happened, it has.
Okay, thank you. Thank you, Mr. Chair.
Delegate Simmons.
Thank you. How you doing, Delegate Foley? To the vet, how you doing, sir? Thank you for coming out. Just a couple of questions. One being that, as a vet, do you feel that you come across a lot of cases where you are required to refer over to enforcement about things you're seeing in your practice about abuse?
Well, I'm actually employed by Montgomery County Office of Animal Services, so I'm not in private practice at this point.
Okay.
I work directly with the law enforcement side.
Okay.
And with the private practice, it was in Virginia. I did see a few cases. I have learned a lot since that time and realized there were probably a few I should have sent. But you know, it's you know, life's a growing process. So, but yes, I mean, it's out there. It happens, and we need to, you know, educate more in my industry so that people are more aware of what the red flags are for things they should be reporting.
Okay, thank you. Is any one of y'all able to speak to the insurance required or the insurance of vets, of insuring animals? I'm sorry, excuse me. Anyone?
Yeah, we're not in the insurance business, so I'm not really I don't know of any of us that have been involved with pet insurance. Is that what you're talking about?
Yeah, I'm trying to see if there's any disparities between people that have insurance compared to those who don't when you talk about animal cruelty.
Most people insure their pets through their veterinarian, whoever they're, because they'll have a plan for them so that they can take care of their animal.
Well, if I could jump in, I mean, there definitely are, you know, pet insurance groups out there. There's quite a few of them, in fact, but they are generally people still have to pay up front and are reimbursed rather than having a copay or something like that. So I can only speak a little bit to it just from the private practice side of it when I did deal with that. But it is a growing industry that more and more people are taking part in. And it's certainly got its benefits for people that when they get sudden expenses in particular.
All right, thank you all very much. And I believe that concludes the hearing on House Bill 405. We're going to go to House Bill 440 from Delegate Charles. And we have two people signed up, both virtual, Eric Smith and Jana Parker. And Delegate Charles, you'll have 3 minutes when you're ready.
That's it. That's all we need. Listen, thank you all. To the Judiciary Committee, thank you for the opportunity. Mr. Chair, thank you again for allowing me to come before you to address this bill. This is a bill that I brought forward last year, and we did not have a Senate cross-file, but to my surprise, we have a Senate cross-file this year, and the bill has made it out of the Senate to second reader. And so hopefully we can do the same over here because it looks like it's moving very fast. So hopefully we can get a favorable vote on this bill. What this does is it allows for the courts to have expedited hearings for child custody proceedings. Like other states, Maryland requires judges to make decisions about child custody and visitation based on the best interest of the child. In Maryland, and the counties follow the common law understanding of what constitutes the best interest of the child. However, while important, the definitions of the best interest are broad and are subject to interpretation. Custody hearings cannot be prescribed. Rather, each hearing is in fact based on each child and family. Custody hearings are scheduled and decided on a case-by-case basis. Evidence suggests that judges and magistrates often too narrowly define the conditions for warranting an emergency hearing based off of imminent danger to the child, and anecdotally, do not consider child relocation to constitute a danger. More often than not, emergency hearings are not approved when based solely on child relocation and custody issues and petitions. Because the threshold is so high for emergency hearings to be granted in matters pertaining to child custody and relocation, this bill seeks to amend the Annotated Code of Maryland 2019, Replacement Volume in 2022, Supplement Section 9, 106, Article of Family Law, to require the courts to schedule a hearing on a certain petition regarding the proposed relocation of a child who is subject of a custody or visitation order to an expedited basis under certain circumstances. This is an important issue. This happens all the time. If you talk to any of your colleagues in here that are family law attorneys or any family law attorneys that you may know, this issue is a very real issue where parties can have a joint physical and legal custody order and another party can then take the child out of state and it's not considered abduction, it's not considered a violation of the order. You cannot get an expedited hearing to get in front of a judge. What this will do is force the courts to have expedited hearings to address this issue beforehand. So thank you.
All right, next we will hear from Janet Parker for 2 minutes.
Thank you. My name is Janet Parker. I'm a resident of Prince George's County, and I'm speaking in support of this specific bill. I just want to highlight some things that this bill would do. I know a lot of times if you flip on your TV, you always see these commercials about fathers being more involved, parents being more involved, and what this bill does is it helps ensure there's an equity in relation to custodial matters so that both parties can be involved, and that it's really looking at, I don't want to use the term evening the playing field, but really making sure that the judges are objectively looking at the situation. If a parent takes the child out of the state or into another environment, and then by the time the custody is heard, that child has become acclimated to that environment, it's like, oh, well, let's leave them there, when in reality, they may not and should not have been removed from the environment that they're in without there being a discussion around that, so that both parties can come to a mutual and appropriate decision for the child. I am thoroughly in support of this, not just because I think it is a good move for all the families across Maryland, but I think it sets a precedent in moving our state forward to ensure that there is equity within custodial matters between men and women and just spouses in general. Thank you.
All right, and we do not have Eric Smith on the Zoom, so we'll go to questions. Delegate Eric Hand.
Thank you, Mr. Chair. Thanks for bringing this bill forward. I'm just looking at the Senate version. It looks like it's a little different. Can you just tell us what the differences are between the version they passed and the version you're proposing?
Yep. So the Senate bill, we made some amendments on the Senate side, and Senator Carter and I agreed on the amendments to the bill. And so we do have amendments that I will be bringing to the committee so that the bill totally matches. But what this bill does is it takes out the 40 or more miles that we originally placed into the bill that addressed how many miles you needed in order to have this custody hearing take place, to changing it to that would significantly interfere with the other parent's ability to maintain the predetermined parenting time schedule. So if this can have a large impact on the custody order, this will allow for them to have a expedited hearing.
Okay, and I did hear that. So how quickly are we talking about? I mean, a lot of contracts, my contract, for example, says 60 days notice, but everybody's contract they sign with their ex-partner is different. Do you have some kind of concept of what kind of timeline you're actually looking at? Because Judiciary said it would be quite difficult to accomplish in their letter.
So typically when you file for an emergency petition, if the child is actually in danger, you typically get in front of the courts within 7 days. That's a typical timeline. But outside of that, if it's not an emergency, what ends up happening is it can take 6 months before you finally get in front of a judge. And by that time, the best interest of the child standards typically kick in, where the child, as Ms. Parker already stated, the child has become familiar with the new environment. So they're in a new school, they're in a new state, and at this point in time, it won't be in the best interest for that child to be picked up and moved again after they just got acclimated into the new environment. So going from a 6-month possibility of getting in front of a judge to 7 days is a very, very important step in fixing this issue.
And is your goal just to address the issue of removal from the state? I mean, for example, my contract doesn't allow moving out of the state, period.
Right. So originally, when we put the bill together, the 40 miles, because where I represent Prince George's County, we're in we have Virginia right across the border. We have D.C. right across the border. If a party was to move a child to a far out part of Virginia, which would necessarily take too long for you to get the child back and forth to school, that could be an impact on that child's schedule, because the parties, may have an agreement where they're taking the kids to school 7 days. They may have them throughout the week. So because of that was pulled out because it was too ambiguous. They pulled the 40 miles out and just made it an impact, a significant interference with the other party's ability to co-parent.
Okay, all right, thanks for clarifying.
Delegate Young.
Actually, I think that my question just got answered. It was going to speak to how long folks might currently be waiting. I think you just mentioned it'd be like 6 months. And I can see where that could become a problem if the child already transitions and you broke that down to how that impacts the best interest of the child analysis. So I'm good.
Delegate Conway.
Mr. Chairman, thank you, Delegate, for bringing this bill. Where is this term significant impact defined?
It's not defined. This was language that we agreed upon with the Senate, and we can make an amendment to add a definition that's significantly.
No, I'm confused as to who is we.
We?
Yes, you
Myself and Senator Cardin, who's the cross-file in the Senate.
Yes. And so you agreed to use significant impact?
Yes.
Well, we're not really sure what that means. Because it could mean one
It can
thing,
be ambiguous. So and the answer to that is I can put forth an amendment that would actually define significant impact so that it won't be as ambiguous and it can be straight to the point for the judges to make a defining.
You think it would be too extreme to say something like to stay within the state limits as a beginning, maybe?
Well, I think if we confine it to the states, especially when you have places like Prince George's County that has Virginia, that has D.C., it's not necessarily impact because they're moving out the state. Somebody moves into southeast D.C., but the other party lived in Suitland. It's literally across the street from each other. So it's out of the state, but it's not necessarily a strong impact on the day-to-day for the child.
Okay, I was just trying to offer you a suggestion. Thank you.
But I appreciate that.
Further questions for the delegate? All right, seeing none, we thank you very much. I think, did we hear from Ms. Parker as well? Yeah, okay. Thank you all very much. That concludes the hearing on House Bill 440. We're now going to our last bill, House Bill 600. Delegate Lopez. Who, are they all virtual, I think? Lisa?
Yes, they are.
Yeah, Lisa Jordan, Jennifer Tisdale, Caroline Thorne, Peyton Ihemi. Going to start to see there's Ms. Tisdale, Ms. Jordan. We have at least those two. We'll wait and see if we get more. But Delegate Lopez, if you'd like to go ahead for 3 minutes, that'd be fine.
Thank you, Mr. Chair, Mr. Vice Chair, colleagues in Judiciary. Good afternoon. For the record, my name is Delegate Leslie Lopez, and I'm here to ask for your favorable support of HB 600, which establishes a task force to address women's digital rights, specifically as they pertain to cyber flashing and deepfake porn. Cyber flashing, as the name suggests, occurs when someone is sent an unsolicited lewd image. Deepfake porn is when an image of someone's face, usually a woman's, is digitally manipulated into sexual material that is then disseminated across the internet. Colleagues, I will admit to you that this is not the bill that I wanted to introduce originally. This fall, I worked with advocates, legal scholars, and victims to draft a bill that would directly tackle these issues. However, upon review by the Attorney General's office, it appeared there would be significant constitutional issues. That is why I am asking that the state dedicate resources to analyze and address these legal issues. Outside of my own experiences of simply being a woman on the internet, this effort began in earnest on Sine Die of last year, when my friend Jen Tisdale, who you'll hear from today, reached out to tell me that she had been receiving illicit images and asked what protections might be in the law. Well, what I found was that there were no protections, but instead there was a large gaping loophole that has a huge impact on women, particularly young women in our state. Let's start with cyber flashing, and here's an alarming statistic. According to Bumble, a dating app tech company that you'll hear from today, 48% of women between the ages of 18 and 24 have received this type of sexual unsolicited image. I'll say that again in a simplified form. Half of young women have been cyber flashed. Many of times they receive these images in direct messages on apps, but that's not the only way an unsolicited image can be sent. They are frequently shared in public spaces using what's called as an airdrop. As we return back to pre-COVID norms, people are returning to large public events like concerts, learning in large lecture halls, where images can be airdropped in mass. People riding public transit are also targeted in the same way. Considering that our metro lines are linked with jurisdictions who have or are currently tackling this issue, Virginia and DC, we are out of alignment with our neighbors. If you're riding the metro, you are only protected during only a portion of your commute. Let's talk about deepfakes. Deepfakes can be used for educational or entertainment purposes. However, upwards of 90% are of non-consensual porn with women. What's even more troubling, according to an article in the Washington Post just a few days ago, is that many women are not even aware their image has been stolen or exploited. I want to draw your attention to written testimony from law professor Rebecca Delfino at Loyola Law School. Her expertise speaks to the harms that occur from deepfakes and the unique legal area they occupy. The negative consequences that come from these images are often detrimental to the women who are victims to them, from the negative mental health impacts. To finish my sentence, by convening experts from Maryland agencies, nonprofit organizations, state's attorneys, like those you'll hear on my sponsor panel today, HB 600 will ensure that Maryland emerges as a leader on both of these issues. Women have the right to exist in public spaces without fear of sexual harassment or victimization, and Maryland has a chance to commit to that with the passage of this bill.
All right. We'll hear from witnesses now. We'll hear from, let's begin with Jennifer Tisdale. Then we'll hear from Lisa Jordan, and then Ms. Thorne.
Thank you. Hi, my name is Jennifer Tisdale, and I am a resident of Anne Arundel County. First of all, I want to thank everyone for being here today and allowing me to speak about an issue that not only have I been personally affected by, but every woman I know has been affected by it. I would like to say that again. Every woman that I know has received an unsolicited lewd photo, whether in a DM via social media, or a dating app, or even in a text. Yesterday, I entered the words unsolicited pic into the Twitter search bar and was met with countless tweets from people sharing their stories about how they were violated in this fashion. One Twitter user wrote that she received 2 on Valentine's Day. Another said, I got my first unsolicited pic of the day. Her first pic of the day. The tweets were posted by enough people that there were several in an hour, and these are just the ones that included the words unsolicited pic. And this is just Twitter. Personally, I've been on the receiving end of so many unwanted lewd photos that I couldn't possibly count them. Each and every one of them was sent by someone I didn't know, had never met, and did not follow on social media. While I appreciate the efforts being made by social media companies and various other corporations to protect people from these unsolicited images, they always put the onus on the victims to avoid the picture. At that point, the message is, if you clicked on a blurred image or you checked a separate folder, then that's your fault. And the only actions that I'm aware of that are being taken against the sender are to maybe ban them from the site they use. Then they just start a new account and the process begins anew. I'm asking you to place the blame where it belongs on the people sending these photos. I'm lucky in the sense that I process uncomfortable feelings with humor, but many people are traumatized by these images. And I know that seeing women making jokes about it can be confusing, but it's important to not base these actions on the images, on the reactions of another. Please, please stop this from happening. Thank you.
Thank you. Ms. Jordan, please, for 2 minutes.
Good afternoon, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of House Bill 600. Thank you, Delegate Lopez, for introducing this bill. Thank you, committee, for allowing me to virtual in while I am under the weather. I also just want to particularly thank Catherine Rowe, who wrote an 8-page, extremely detailed letter explaining some of the constitutional barriers to ending this abhorrent practice. And I think Ms. Tisdale has really given you a sense of the real harm that these images do to us and the prevalence of cyber flashing. I'll also mention that in past years, some of the members of this body have approached MCASA asking about the difficulties that would occur from deep fakes used in the political arena, and whether deepfakes might be used to make one of you seem like you were doing something or saying something that you had not done or said. So it is certainly not only something that is important for the sexual imagery arena, but also for you all as public officials who run for office. Generally speaking, MCASA is not a super big fan of task forces. We believe that you're elected to make decisions and they're important to make, but this is an extraordinarily complicated issue. We do not want to violate the Constitution. We believe in the Constitution and that you should not pass unconstitutional bills. And so a task force really is the best way to look at all the myriad of issues and try to make sure that we can actually protect people from unwanted sexual imagery. For these reasons, the Maryland Coalition Against Sexual Assault supports House Bill 600.
Ms. Thorne, please.
Hello, Mr. Chair, Mr. Vice Chair, and members of the Judiciary Committee. Thank you for the opportunity to testify today, and thank you, Delegate Lopez, for introducing this bill. My name is Caroline Thorne, and I serve as the Director of Government Affairs for the University of Maryland Student Government Association. And on behalf of the SGA, I respectfully request a favorable report of this bill. Approximately 2/3 of college students have experienced sexual harassment in some form, particularly in the form of cyber flashing. This is a huge problem on college campuses with students living near hundreds of other students daily, in dorms, apartments, going to large lecture halls, or sporting events. And technology allows us to connect with others constantly and easily, and in some cases, somewhat anonymously. I've personally experienced cyber flashing, and as Ms. Tisdale said, the vast majority of my friends and peers have as well. Particularly, I experienced the iPhone AirDrop function, as Delegate Lopez mentioned. This allows an individual to send a photo or video to anybody in their vicinity who has that function turned on without needing their contact information. The name associated with the send can be changed, and it's often not reflective of who necessarily actually sends the picture, leading to issues with accountability. I personally have since turned this feature off, but this occurs through many other platforms such as texting, Snapchat, dating apps, and many more. This is really an emerging issue with little to no accountability for perpetrators, and it deeply impacts college students on campus. Creating this task force to understand the issue and identify well thought out legislative solutions is an essential step to addressing this harassment. Thank you for your time.
Ms. Ahim, please.
Thank you and good afternoon. First of all, thank you for the committee for considering this important piece of legislation, calling for the task force, and thank you, Delegate Lopez, for introducing this bill. I'm here as the Vice President and the Head of Public Policy for a company called Bumble. If you're not aware, it's a woman-founded and woman-led company dealing in online relationships, whether they be intimate, friends, or entrepreneurial. The reason why we're here and helping support this bill is firsthand knowledge. The majority of our users are women. And because of that, we're constantly speaking to them. And this was brought to our attention several years ago in 2019, informally that this was happening. We created tools on our own side to help block it, but we realized that just solving it on just one tech platform is not the answer. This is an issue of bad actors. This is an issue of education, of people not realizing in some senses that this needs to stop or that it's happening. But it's also important that we mitigate this behavior. We have supported this globally. So we're coming here from not just a sense of like what happens in one state, but globally, whether it's the UK, Australia, and other places in the United States. It is a growing and emerging issue, and it's continuing to grow. I want to also speak about the harm. Some people may laugh it off, but if this were to happen in real life, there are laws in every single state that prevent this type of activity from happening. And if one does it, there's ramifications. What's happening is online, there is a gap. And that's really just because the internet laws have not caught up to real life. And that's what we really need to close in this space. I want to point out too, this hit the airs in the summer when this was happening on airlines with children and everyone else that was also receiving them. So that's why we're here to support this. We strongly, strongly urge you to do the task force and pass this bill.
Thank you very much. Joyce King is supposed to be on virtually, but I don't see her. We don't have her virtually. Okay. Debbie Feinstein, I think, was also signed up, and she was signed up to be here in person. But we don't have her either virtually or in person, so, okay. Yeah. There you go. That's fine. We will take questions then. We'll go to Delegate Arikan.
Thank you, Mr. Chair. Thank you, Delegate, for bringing this important bill to our attention. This is obviously a huge issue for literally half the women that I know. So thanks for addressing it. Sorry you couldn't bring something with teeth in it yet, but hopefully we can work through some of the constitutional issues. I wonder if you might just touch on for a second what those might be and what, if anything, other states have done to address those concerns.
Sure, yeah. So the real issue comes from the idea that an image, there's First Amendment rights associated with images. Right. And so to Peyton's point earlier, it's illegal for indecent exposure in real life. In Maryland, it's a $1,000 fine, up to 3 years in prison, right? Because it's an image, and you're using technology to do the same thing, it's constitutionally protected. In terms of video and deepfakes, it's similar. It's legally considered expressive. And so there's, again, First Amendment rights with that. And so we definitely don't want to infringe on anyone's First Amendment rights. And it's just a very legally complicated tightrope to walk. The first state to actually enact this legislation was Texas, which is not particularly known for being, progressive or friendly to women. But Texas was the first state. It's a $500 fine in Texas. In California, there's civil liability. And so if you receive one of these images, you have, cause of action is the term, to sue someone for them. Virginia just passed this past year through their General Assembly, which was unanimous. It received bipartisan support, unanimous in both chambers. They passed legislation that would have this echo trespassing. So it's considered digital trespassing, and that's where it's in our code, and it's a civil offense. Or their code, and it's a civil offense. In our code, it's far more complicated because trespassing is a criminal offense. And so our state is just very, very difficult.
Yeah, okay, that really does help clarify some of the concerns and sort of where we might be going from here. So keep us posted on how it goes.
Sure.
Thank you, Mr. Chair. Just real quick, thanks for the great idea for the bill. Initially, you talked about women, and then the young lady from University of Maryland had mentioned at least 2/3 of campus members. So I think it's not just a women's issue, although it seems like this deals with women more, but there are also men and other groups that would have great interest in this. So I'm just wondering if you're expecting to have a diverse group of people on the task force to make sure that you cover all your bases.
Sure. So right now, as the bill is originally drafted, there's 12 people on the task force. There's people from this illustrious committee, and a representative from JPR, a representative from state's attorneys, from whatever GOCAP is now called. There's like MCASA would be represented. There's community members who are represented, and I would like to think it's a good sign that I'm getting amendments for all sorts of folks who want to be added to the task force as well. And so the goal is to make it as comprehensive as we need to be. Once you introduce this idea out there, it's really amazing the outpouring of interest there is and support for it. And so I think there's probably many communities who would benefit from being included.
Thank you.
Its question. I was wondering, did you have any breakdown or consideration of the different groups such as LGBTQIA and 2S?
I don't, but that doesn't mean it's not out there. I think that there's a lot of scholarship in this area that with a little bit of digging, I could send it your way for more data. And I would also...
No, I was asking for the task force.
Oh, for the task force. Yes. There isn't someone specifically from that community assigned. From those communities. But I'm open to discussions.
Yes, well, I was just giving you that as a suggestion. And in reference to your deep fakes, I was wondering, can you comment on this? Because I had this question several years ago in reference to my own image. Mm-hmm. And I found that www.upcouncil.com, items found in nature such as DNA and human faces are not deliberately created by man. Instead, they're considered a natural phenomena. Therefore, they are not subject to intellectual property rights.
Well, I guess that's just one more reason why a task force is needed, Delegate. It's even more complicated than we thought.
Well, if your task force says, yeah, you can copyright your face, but the law says you can't copyright your face, I mean, what do we need to study?
Well, I think it's complicated, and I think it goes deeper than that. There's First Amendment issues, but I think people have a right to their privacy, even when it's something that could be posted on social media. That's where a lot of deep fake porn comes from. There are AI bots out there that scrub totally benign images of women, like on Instagram, for example, and then those images are stitched into other video materials and made to seem seamless. Sometimes deep fakes can be benign. Like those of you who've seen Fast and Furious 7 might know that Paul Walker, one of the main actors, died during the production, and his face, they used deep fake technology to finish the film. And I'm sure it's made millions of dollars, and you probably don't even know which one's real and which one's not. Sometimes it can be used for educational materials, like, Abraham Lincoln can be resurrected to deliver the Gettysburg Address. There's a famous one of David Beckham speaking 8 languages, but he only really speaks 1 language. I mean, there's benign purposes, but...
one person's benign might be another person's obscene, because if you took certain images of Martin Luther King and made certain statements, I might be particularly offended, but I thank you for bringing the bill.
Thank you, Mr. Chair, and good afternoon. This question is for Ms. Thorne. It's nice to see you again, and Ms. Tisdale is welcome to chime in as well. I must admit, Ms. Thorne, I'm not a hip person, so I hadn't heard of cyber flashing until you brought it up today. So my question is, and of course you don't have to share any details that you don't want to, but can you talk you said you were a victim of cyber flashing and things like that, and can you talk about the emotional or psychological toll that took on you, so we can see, the real world consequences of cyber flashing?
Yeah, for sure. I won't go into too many details just because the nature of the image obviously is not appropriate. But when you go to school, you're obviously there to learn. You're there to focus on your classes, meet peers. College is a really important part of socialization for young people, particularly heading out of the COVID-19 pandemic, where most of the people who are in college right now had to be remote or online, or they had to make that transition not in person. So this is really the first time a lot of students are getting back into those social situations again, including myself. So being in a public space with many people for the first time really in a couple of years, and then having something like that happen is really just very shocking emotionally, just because you're on your phone or you're on your laptop and all of a sudden something very crude pops up. It's not really, in the way AirDrop works, it just shows you a preview of the image. It doesn't fill your whole screen, but you still see what the image is. And that can be very emotionally hard, especially for students, I would say, who have experienced sexual assault in the past. It can be very triggering for students just because all of a sudden you're going about your studies, you're on your phone, all of a sudden something pops up that you're really just not expecting to see in an institution of education. I hope that answers your question.
Thank you, Ms. Thorne, and thank you for your courage in explaining your story. It must not have been easy.
Thank you so much, Delegate Lopez, for bringing this bill. My question is more for the young woman from Bumble. You mentioned that you all have taken certain steps to kind of deal with this issue. What type of steps would you like to see other companies like yours and other technology companies do, I guess a little bit more specific, to kind of deal with these or prevent these circumstances from occurring?
I'd like to point out, and thank you for the question, that each platform is different, so they all can't mimic the same type of technology. Our communications are one-on-one because we're trying to build relationships and friends. So the tool we have is called Private Detector, is an AI tool, artificial intelligence tool, that blurs it as soon as it comes in, and then you as the user clicks yes or no if you want to see it, right? We have open sourced that as of 4 months ago, particularly to get to this exact point. We open sourced it, we put it out to the press, and we put it out to the public so all companies and organizations can use it. But I do want to caveat that one-to-one type of communications like ours, it's easier to do that. When you've got one-to-many mass communication, which some of the witnesses here have talked about, social media, it doesn't work. And I also want to put a lot of the emphasis on, when we talk about free speech and the First Amendment, that not all speech is protected. And harmful speech has already been tested time and time again not to be a protected speech, and that's been left in the hands of policymakers like yourself and the community. So I just want to put that caveat in there too. It's not always a technical fix. Sometimes it's a policing of people and behavior.
Thank you.
Seeing no further questions for this panel, thank you all very much. We have 2 more people who are going to testify. Joyce King and Debbie Feinstein both just joined us, so we're going to hear from them for 2 minutes. Oh, I'm sorry. I had 2 more questions. Okay, well, let's do this. Let's hear from Ms. King, Ms. Feinstein, and then I'll take 2 more questions. So let's hear from Ms. King, please, and then I'll come over here.
Good afternoon, Mr. Chair, Mr. Vice Chair, committee members. My name is Joyce King. I am Chief Counsel here at the Frederick County State's Attorney's Office, and I lead the Cyber Crimes Task Force here in Frederick County. I've been prosecuting child exploitations for almost 10 years. And apologies for the confusion. Ms. Feinstein and I were troubleshooting and both had conflicts, but now coincidentally both were able to join. So I don't want to be redundant in our testimony, but we do believe that this type of conduct should be criminalized regardless of the perpetrator's motivation, that this is harassment, that if you were to flash an individual in person, that is a crime, but to do it digitally, it's somehow not. I love this idea from Delegate Lopez to start a task force to further discuss, because this is a complex area of law and it has serious implications. So MSAA, on behalf of the Maryland State's Attorneys Association, we support and look forward to serving on this task force.
Ms. Feinstein, please.
Thank you so much. Good afternoon. My name is Debbie Feinstein. I'm Chief of the Special Victims Division for the Montgomery County State's Attorney's Office. I'm here on behalf of myself, my boss, John McCarthy, as well as the Special Victims Subcommittee of the Maryland State's Attorneys Association. I'm going to say me too to Ms. King, and thank you for giving us the opportunity to testify on Zoom.
Excellent testimony. All right, Delegate Munoz and Delegate Crutchfield.
Thank you, Mr. Chair. I believe this might be a question for the sponsor. Going over the list of everyone who's involved, I don't see anyone particularly focused or with an expertise on minors. And so I was just curious, is this already covered and protected in Maryland state law in regards to minors, this issue?
Sure. So I don't know what protections already exist for minors. I know the focus of this work is exclusively for adults. I think there probably is a lot of work to do for exposure to minors, but this task force is just specifically for adults.
So if I could just address briefly the question, would that be okay?
That's fine.
Thank you. Sexual abuse of a minor, which is already codified in the Maryland Code, does cover exploitation of minors, but only when the children are in a relationship of trust, supervisory, care and custody, family member, or household member. So there are protections for children, but again, defer to the sponsor because these are for adults. This task force is for adults, which is where really there is no coverage at all.
So if a child, like a fifth grader, were sent like a sexual image to their cell phone, or if another student took a child's face and put it on a sexual image and airdropped it to the whole school, there are no protections for that under Maryland law?
There are. I was going to chime in. For situations where it's not a household member, there is a charge of sending obscene material to a minor. So that is covered. It's a very small penalty, and hopefully it's something that we can further discuss in future legislative sessions. But that is a real concern for prosecutors as well.
Thank you so much.
Thank you very much, Mr. Chair. So Delegate Lopez, welcome back. But first of all, I just wanted to know, you seem to be getting quite a bit of media coverage on this bill. What's that all about? What do you think's happening?
Yeah. So a few days ago was Valentine's Day, and I just happened to be minding my own business on social media, and I saw a post of a comedian who's, I would say well-known on the internet, and she was expressing how Valentine's Day seems to be a day where there's an uptick, right? I think as some of the panelists kind of alluded in this type of behavior. And so I responded just as a comment that, yeah, this is a problem, and I'm introducing a bill in Maryland about it. And it's been supported. I think the last time I looked, there's slightly more than 10,000 likes and 300 retweets of it. And so in the past, I don't know what time, I guess past like 12 hours, I think I've done 7 media interviews about this. And in English and Spanish, so it's like everyone's interested. And one of the things I would note is that of those 7 journalists, 6 of them are women. And after the interview was done, each one shared me their story, right? Each one. Wow. Or alluded to a story, right? And so I don't, perhaps, within the General Assembly, our peer group isn't necessarily exposed and as vulnerable in the way that other, public-facing women, such as journalists, writers might be, young women might be. But this is an issue of mass and scale and emergent technology. In terms of deep fake, right now, the way that the industry is going, every 6 months, the number of deepfake porn doubles, right? And technology, the nature of it is to evolve and to improve itself. And so it's only a matter of months until people have an app on their phone where they can produce this material. And so we just need to get ahead of it and study it and figure out what we can do.
All right, thank you.
Seeing no more questions on this task force bill, we thank you very much. That concludes the testimony on House Bill 600. That concludes the testimony today. It's only 2:30. I know, that's fine. There will be a voting session tomorrow immediately after the end of the regular floor session. We will have a voting session. Once you're done with that, you're done for the weekend. So just be aware, you need to be here directly right after the floor. With that, we are adjourned.